Rule 112. Preliminary Investigation. Section 1. Preliminary investigation defined when required. Preliminary investigation is inquire or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial, except as provided in Section 7 of this rule. A preliminary investigation is required to be conducted before the filing of complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day, without regard to the fine. Section 2. Offer, Officers authorized to conduct preliminary investigation. The following may conduct preliminary investigation. Letter A. Provincial of City Prosecutor under assistance. Letter B. Judge, Judges of the Municipal Trial Courts and Municipal Circuit Trial Courts. Letter C. National and Regional State Prosecutor, and letter D. Other officers as may be authorized by law. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in their respective territorial jurisdiction. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. Letter A. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of complainant and his witnesses, as well as other supporting document to establish probable cause. They shall be in such number of copy as there are respondents, plus 2 copies for the official file. The affidavit shall be subscribed and sworn to before any prosecutor or government official authorized the administer oath, or in their absence or unavailability before a notary public, each whom must certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. Letter B. Within 10 days after filing of the complaint, the investigation officer shall either dismiss it if he finds no ground to continue with the investigation, or issue subpoena to the respondent, attaching to it a copy of the complaint and its supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant, which he may not have been furnished, and to copy them his expense if the evidence is voluminous, and the complainant may be required to specify those which he intends to present against the respondent, and this shall be made available for examination of copying by the respondents at his expense. Object as evidence need to not be furnished party, but shall be made available for examination, copying or photographing at the expense of the requesting party. Letter C. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavits and that of his of his that of his witnesses and other supporting document relied upon his for his defense. The counter affidavit shall be subscribed and sworn to and certified as provided in paragraph left of this section, with copies thereof furnished by him complainant. The respondents shall not be allowed to file a motion to dismiss in lieu of a counter affidavit. Letter D. If the respondents cannot be subpoenaed or subpoenaed, or if subpoenaed does not submit counter affidavit within the 10 days period, the investigating official resolve the complaint based on the evidence presented by the complainant. Letter E. The investigating officer may set a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be present at the hearing but without the right to examine or cross-examine. They may however submit to the investigating officer questions which may be asked to the party or witnesses concerned. The hearing shall be held within 10 days from submission of the counter affidavit and other documents or the expiration of the period for their submission. It shall terminated within 5 days. Letter F. Within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial.